Muy buenas tardes. Damos inicio a la reunión 2087 del Comité contra la Tortura y me es muy grato dar nuevamente la bienvenida a la delegación de la República de Azerbaiyán para continuar nuestro diálogo que iniciamos el día de ayer. Y de inmediato le ofrezco la palabra a su excelencia, el señor Samir Sharipov, jefe de delegación y viceministro de Relaciones Exteriores. Tiene usted la palabra. Adelante.
Dear Mr. Chair, distinguished members of the committee, yesterday we had a fruitful dialogue during which a number of issues was raised by the committee members, and due to the time restraints, my delegation was able to address part of the questions raised, and today is ready to provide committee members with the further updated and detailed information. Let me now, without taking much more time, to give the floor to the members of our delegation. And now, first, I wanted to ask to take the floor Mr. Fazil Kuliyev, Deputy Minister of Internal Affairs, to address the issues raised yesterday by Mr. Todd Backwell and Lee Huawen on the issues of access to justice and lawyers, application of the rights of detained persons, the right to be informed about the detention and arrest, the rights of defenders and journalists, human trafficking, increasing the professional training of personnel, and issues related to the juvenile justice. Please, Mr. Goliev, you have the floor.
Спасибо. Уважаемый господин председатель, уважаемые члены комитета, работа по полной и эффективной реализации рекомендаций Комитета ООН против пыток в повседневной практической деятельности проводится на основе специального плана и находится на постоянном контроле. Согласно национальному законодательству, руководство мест содержания полиции обязано немедленно после задержания обеспечить подозреваемому возможность устно или письменно сообщить о своем задержании родственникам и близким. Учитывая, что многие задержанные граждане могут не знать о своих правах и обязанностях, в полиции на видных местах установлены специальные телефонные аппараты для связи с родственниками и иными лицами, а также с номерами горячей линии Института омбудсмена и Азербайджанского комитета против пыток. Там же размещены стенды с текстом Закона об обеспечении прав и свободы лиц, содержащихся в местах лишения свободы на азербайджанском, русском и английском языках. Для того, чтобы лица, доставленные в полицию или задержанные, могли более тщательно изучить свои права, им выдаются отдельные буклеты с указанием их прав. При необходимости содержание буклета разъясняется в устной форме. В соответствии с правилами для подробного документирования содержания в полиции на каждого задержанного составляется электронный информационный листок единого образца, где отражаются все сведения о пребывании задержанного в местах временного содержания, в частности, о проведении медицинского осмотра, распорядке дня, информировании родственников, встречах с адвокатом, законными представителями и так далее. Все места временного содержания полиции оборудованы системами видеонаблюдения. Перемещение задержанных и их общение с работниками находится под постоянным контролем ответственных сотрудников. Для реализации прав задержанных на встречу со своими адвокатами и законными представителями в конфиденциальной обстановке решением Министерства внутренних дел в октябре прошлого года в местах временного содержания органов полиции выделены специальные комнаты, и созданы все необходимые условия для проведения таких встреч. При этом нет никаких ограничений, как по времени, так и по количеству встреч задержанных с адвокатами и родственниками. Правила эти неукоснительно соблюдаются, и их нарушение влечет за собой незамедлительное привлечение к ответственности. Особое внимание уделяется вопросам оказания медицинской помощи задержанным и арестованным, которые подлежат немедленному медицинскому осмотру с момента поступления в орган полиции. На каждого из них оформляется специальная медицинская карта, в которой отражаются все сведения о состоянии здоровья, а также тех или иных телесных повреждениях, если они имеются, и причинах их возникновения. В случае, если арестованный или задержанный заболел, либо получил телесные повреждения во время пребывания в местах временного содержания, проводится медицинский осмотр, результаты которого письменно сообщаются его адвокату. При необходимости задержанный в обязательном порядке обеспечивается медицинской помощью. Им предоставлено право самостоятельного выбора медицинского учреждения или специалиста для проведения обследования. В целях расширения права задержанных и арестованных на самостоятельный выбор медицинского учреждения или специалиста в настоящее время на стадии рассмотрения находятся законопроекты об отмене порядка о вынесении по данному вопросу постановления. Учитывая, что в полиции задержанные содержатся на достаточно короткий срок, держать штатных медицинских работников для каждого из почти 85 мест временного содержания не представляется возможным. Поэтому медицинский осмотр задержанных проводится приглашенными врачами территориальных медицинских учреждений. Для контроля за положением дел в местах временного содержания в вопросах соблюдения прав задержанных налажена четкая система реагирования на все заявления и жалобы, особенно связанные с информацией о случаях пыток и других незаконных действий. Проверка по таким фактам осуществляется Управлением внутренних расследований Министерства. В случае подтверждения полученной информации принимаются меры дисциплинарного и иного наказания в соответствии с законом. При наличии жалоб, связанных с пытками, и бесчеловечным или унижающим достоинство обращением, а также подозрений в том, что телесные повреждения могут быть нанесены в результате такого обращения, информация об этом незамедлительно направляется прокурору. В целях изучения условий содержания и соблюдения прав задержанных и наличия возможных жалоб созданы необходимые условия для проведения прямого и неограниченного мониторинга в местах временного содержания со стороны наблюдателей от правительственных и неправительственных организаций. Таким образом, в 2020-2023 годах проведено в общей сложности 358 подобных мониторингов. Определенные шаги предпринимаются и в направлении развития ювенальной юстиции. Справедливое правосудие в отношении несовершеннолетних должно совершаться с обязательным учетом их физиологических и психологических особенностей. Согласно законодательству, опрос несовершеннолетних проводится с обязательным присутствием их представителей. При необходимости обеспечивается участие специалиста-педагога, врача, а в случае, когда несовершеннолетние являются подозреваемыми или обвиняемыми, то и адвоката. Несовершеннолетние не могут отказаться от помощи адвоката, и он назначается в обязательном порядке. Избрание меры пресечения в виде ареста для детей допускается только в случае совершения ими менее тяжких насильственных, тяжких или особо тяжких преступлений, и только после тщательного разбирательства. Законодательством запрещено содержание ребенка под стражей вместе со взрослыми, за исключением случаев, когда этого требуют его интересы. Хотел бы также отметить, что для эффективного решения задач, стоящих перед органами полиции, в том числе и в области защиты конституционных прав и свобод человека, только в 2020-2023 годах в многочисленных семинарах, тренингах, курсах и онлайн-мероприятиях, организованных в нашей стране и за рубежом по обсуждаемой тематике, было задействовано около 52 тысяч участников от Азербайджана. А на занятиях в системе профессиональной подготовки большинство тем посвящено правам и свободам человека. По завершению каждого учебного года в специальной комиссии проводится проверка уровня приобретенных сотрудниками знаний, а каждые 5 лет их аттестация. Кроме того, значительно расширена учебная программа Академии полиции. В рамках предмета «Уголовный процесс» и «Криминалистика» предусмотрено проведение лекций, семинаров, практических занятий по изучению тематики проведения допросов задержанных и арестованных. Учебные программы текущего года предусматривают также изучение тем, включенных в подготовленные Европейским Союзом методические рекомендации о проведении допросов и о принципах эффективного проведения опросов. Изучается порядок работы с задержанными и в школе подготовки рядового и младшего начальствующего состава. Ведь в основном именно эта категория сотрудников, как правило, несут службу в местах временного содержания. Проводимая работа по реализации положений Конвенции ООН против пыток была обсуждена и на заседании коллегии в октябре 2020 года и приняты необходимые решения по дальнейшему повышению эффективности работы на данном направлении. Что касается случаев самоубийств в местах временного содержания, то за 2020-2023 годы зарегистрировано 7 подобных фактов. По каждому из них проведена служебная проверка, и 27 сотрудников полиции привлечены к дисциплинарной ответственности за отсутствие должного контроля за задержанными. В том числе 7 уволены со службы, 1 освобожден от занимаемой должности, в отношении 19 применены другие меры дисциплинарного воздействия. Особое внимание уделяется такому важному направлению деятельности, как борьба с торговлей людьми. В 2020 году утвержден 4-й национальный план действия по борьбе с торговлей людьми в Азербайджанской Республике на 2020-2024 годы. В результате мер, принятых в рамках выполнения данного плана, за последние 4 года выявлено 627 преступлений, связанных с торговлей людьми, и 14 фактов привлечения к принудительному труду, жертвами которых стали 374 человека. За торговлю людьми привлечено к уголовной ответственности 69 человек, из которых 50 приговорены судами и различным срокам лишения свободы. Утвержденные постановлением Кабинета министров Азербайджанской Республики от 3 сентября 2009 года правила выявления жертв торговли людьми определяют механизмы, позволяющие установить, является ли то или иное лицо жертвой. За этот же период в безопасный приют, действующий при Главном управлении по борьбе с торговлей людьми, были помещены 287 жертв преступлений, связанных с торговлей людьми. В отношении них приняты все необходимые меры по оказанию медицинской и психологической помощи, обеспечению необходимыми вещами для личного пользования. В дальнейшем 39 из них были обеспечены работой, 87 направлены на профессиональное обучение, а 28 оказана помощь в получении удостоверения личности. Отдельное внимание уделялось детям пострадавших. Более 100 таких детей были обеспечены учебными материалами со стороны Министерства внутренних дел, 44 вовлечены в программу дошкольного образования, 54 обеспечены свидетельством о рождении, а в отношении 41 ребенка была оказана помощь в установлении отцовства и привлечении их к выплате алиментов. Благодарю за внимание.
With your permission, Mr. Chair, I thank you, Mr. Guleev, for his presentation and contribution. And now I would like to give the floor to Mr. Cengiz Askerov, Deputy Chief of Supreme Court, to provide relevant information on the questions raised yesterday by Mr. Todd Backwell. And I would like to ask you to address the questions within the Article 125 of the Criminal Procedural Code, issue of expulsions carried out on the basis of diplomatic assurances, issue of reliance on confessions, court's approach to allegations on torture, as well as cases related to Toplum TV, Abzats Media, and Söğütlü. At the same time, I would like to ask you, Mr. Askerov, to reply on the question raised by Mr. Erdogan Ishcan related to domestic remedies. You have the floor, Mr. Askerov, please.
Thank you, sir. Distinguished Mr. Chairman, distinguished members of the committee, I'd like to start with the short answers to questions and then turn back to the practice of the national courts of the Republic of Azerbaijan. According to the constitution of the Republic of Azerbaijan, all international agreements adhered to by the Republic of Azerbaijan, including the international human rights instruments, have direct legal force on the whole territory of the state. And therefore, as you might be aware, the European Convention for the Protection of Human Rights and Fundamental Freedoms forms a part of our legislation, and the case law of the European Court of Human Rights also have direct force in the Republic of Azerbaijan and widely practicing by our courts. Firstly, I'd like to refer to the question of examination of diplomatic assurances while examining the question of expulsion of foreigners from the territory of Azerbaijan. According to the case law of the European Court of Human Rights, these diplomatic assurances have some importance, value for examination of such cases, but they don't have a decisive value. Therefore, in the practice of our courts, while there are diplomatic assurances, they don't have a decisive value, and they are being examined together with other circumstances of the case. If there are any considerations of security for the foreigner who is under the expulsion procedure, these diplomatic assurances might not be taken into account. Another question was concerning the reference to or examination by private doctors of the detainees. This question is also arising the practice of our domestic national courts and also the law enforcement agencies also is based on the practice of the European Court of Human Rights. And I can assure you that according to such practice, now where any detainee asks for examination by private doctor of his own choose, then this is ensured, and the private doctor has an access to detainee and provides forensic examination and gives a medical opinion concerning his or her state of health. These cases, a number of such cases were also submitted to the European Court of Human Rights, which they were taken into account. I'd like to draw your attention also to the decision of the Plenum of the Supreme Court of the Republic of Azerbaijan of 24 December 2021 concerning the judgment of the court in the criminal cases, which is also based on the case law of the European Court of Human Rights and addresses the whole range of matters which can arise in the criminal proceedings, from the arrest to the delivery of the final judgment. And several questions raised by members of the committee will also have answer in this decision of the plenum. For example, the Article 125 and the burden of proof. What are the proceedings when there are complaints or concerning or allegations concerning ill treatment at the pretrial stage? The practice of the national courts is based on the case law of the European Court of Human Rights, and I'd like to bring you an example of the approach of the European Court of Human Rights, which was expressed in its recent decision in the case of Ismailov versus Azerbaijan. It is of February 2024, where the lawyer alleged that he was ill-treated by the police, by the members of the police. And the court here, and I quote, said that it cannot be said that the applicant raised an arguable claim or made a credible assertion. In view of that conclusion, it cannot be said that the authorities were under an obligation to investigate further the applicant's allegations. So the approach of national courts is the same. An individual has to bring arguable claim, at least any evidence or concordant evidences that he was ill-treated, and then upon these claims, allegations, the court starts investigation, or on its own in the trial, or it refers this investigation to the prosecutor's office, then waiting for the response of the prosecutor's office on the results of the investigation. Concerning the reliance of the criminal proceedings on the confessions by the detainees, this question has been also addressed in the decision of the plenum of the Supreme Court, and it says that the court judgment can only be based on the evidence investigated directly during the trial. That means that any discrepancy in the statements by the accused or by witnesses given at the pretrial stage or during the trial should be investigated only during the trial and be examined together with other concordant or dissenting evidences. The complaints procedure, I told about it. It's being also here described. The question of domestic remedies of the victims of ill treatment, the courts, according to our legislation and also to the practice of the courts, any individual who has been established as a victim of ill treatment has a right to remedy his violated rights, and we not only the victim of ill treatment, but also those who were unlawfully arrested or who were arrested during the pretrial stage and then were acquitted by the court. They have the right to compensation. Besides, the criminal code establishes the responsibility of those who are responsible for ill treatment. Therefore, we have the cases. These complaints or claims are being examined within the civil proceedings, and we already have several cases or judgments when the victims of unlawful arrest, they received financial compensation, or even the victims of ill treatment, they also receive compensation for pecuniary or non-pecuniary damage. There were also questions concerning certain individuals of civil society members and social media journalists and their arrests. This, I can only say that these arrests are not connected or related in any event to their professional activities, and they were brought to criminal responsibilities for financial offenses, in particular the smuggling of money in large amounts. This is concerning the Abzas Media and Toplum. Concerning Gubade Badoglu, he was brought to criminal responsibility for financial fraud, and it was during the search in his place, it was found about 20,000 of false United States dollars, and therefore he was also brought to criminal responsibility. By I also like to note that several persons, including those whose names were mentioned yesterday, they applied to the European Court of Human Rights with the request for application of interim measures under Rule 39 of the Rules of Court, to alleging their poor health conditions, and to respond to the European Court's request, the authorities organized independent medical examination, forensic examination of the individuals, and submitted to the court all the medical documentation of these individuals, and the court rejected application of interim measures. And the day before yesterday, Gubade Badoglu was pretrial arrest was remitted to the house arrest. I think these are the questions which I should respond. Thank you very much.
I thank you, Deputy Chief of the Supreme Court, Mr. Rascara, for your valuable contribution to today's discussions. And I now wanted to turn to Madam Sadagat Gahramanova, Deputy Chair of the State Committee for Family, Women and Children Affairs, to address the issues related to the activities on combating domestic and gender-based violence and effective protection mechanism existing in the country, as well as the corporal punishment of children and training activity. You have the floor, Madam Gahramanova. Please.
Спасибо. Уважаемый господин председатель, члены комитета, уважаемые участники сессии, я приветствую вас всех. Конвенция против пыток и других жестоких, бесчеловечных и унижающих достоинство видов обращения и наказания – это прежде всего защита прав человека, права женщин, мужчин, детей. Закон Азербайджанской Республики о гендерных гарантиях, гендерном равенстве гарантирует защиту прав человека, включение гендерного фактора во все сферы жизни общества. Государственный комитет представляет годовой отчет парламента республики об исполнении данного закона, что дает возможность осуществлять гендерный анализ как в государственных структурах, так и в частном секторе. Во всех органах местного самоуправления созданы гендерные комиссии для осуществления мониторинга среди семей и формирования гендерных взаимоотношений в семьях выявление фактов насилия и других факторов, унижающих достоинство человека. В стране функционирует закон по бытовому насилию. Указом президента Азербайджанской республики был утвержден национальный план действий по борьбе с бытовым насилием 2020-2023 годы. В целях обеспечения реализации мер, предустановленных национальным планом, во всех органах исполнительной власти созданы мониторинговые группы по гендерному насилию и насилию в отношении детей. Мониторинговые группы действуют во всех районах страны, куда входят представители районных полицейских управлений, прокуратуры, структуры образования, здравоохранения и социальных структур. При выявлении фактов насилия виновный наказывается в соответствующем законодательном порядке. Помимо оказания помощи подвергшемуся насилию, с прошлого года ведется работа с лицами, совершенными факт насилия, и ведется реабилитация детей, находящихся в условиях процесса насилия. В выступлении докладчика был поднят вопрос о подготовке сотрудников правоохранительных органов в деле предотвращения гендерного и бытового насилия. В рамках проекта «Твиннинг» в 2021 году было обучено и обеспечено сертификатами 696 сотрудников правоохранительных органов. Кроме того, более 300 сотрудниками полиции был проведен 20-часовой обучающий курс по домашнему и гендерному насилию и оценке рисков. Образовательные информационные мероприятия были проведены во всех образовательных учреждениях. Был задан вопрос о состоянии горячих линий. За 2020 год была открыта горячая, 2020 года была открыта горячая линия 860, куда поступило 1115 обращений, 915 от женщин и 200 от мужчин. Кроме того, действует детский и женский телефон доверия 117 и 111. Также был поднят вопрос о состоянии сексуального насилия. Одним из приоритетов государственной политики являются трудовые права человека. Доля женщин в составе экономически активного населения составляет 48,3%. В прошлом году комитетом было проведено исследование о положении сексуального насилия. Фактов насилия не было зарегистрировано, но сегодня ведется большая разъяснительная и профилактическая работа в этом направлении. С целью содействия развития экономических прав, предпринимательских навыков сельских женщин реализуется проект технической помощи. В рамках проекта были созданы женские ресурсные центры в регионах страны. Эти центры помогают предотвращать бытовое и гендерное насилие путем преодоления социально-экономических проблем, с которым сталкиваются женщины. В целом 8200 женщин были вовлечены в тренинги и мероприятия на различные темы, проводимые женскими ресурсными центрами. Около 824 женщин начали свой бизнес. Также хотела бы проинформировать вас о вопросах, касающихся защиты прав детей. В целях обеспечения выполнения плана действий по реализации детской стратегии на 2020-2025 годы подготовлен новый проект закона о правах детей. В проект включены правовые нормы о телесных наказаниях в отношении детей. Также в Кодекс Азербайджанской Республики о административных правонарушениях предусмотрено определение санкций к родителям, принимающим телесные наказания, или работникам образовательных, медицинских, социальных служб, спортивных, культурных, оздоровительных и других аналогичных учреждений, ответственных за детей. Подготовлен законопроект о несовершеннолетних. Оба проекта находятся на стадии согласования с государственными органами. Согласно статье 12 Закона о правах ребенка, ребенок имеет право на свободу и личную неприкосновенность. Любое физическое и юридическое лицо, наблюдающее случаи жесткого обращения с детьми, может обратиться в соответствующие органы с просьбой предотвратить такое обращение. Жесткое обращение с детьми, применение к ним морального и физического насилия влечет за собой лишение родительских прав в соответствии с законодательством Азербайджанской Республики, а также административную и уголовную ответственность. Был затронут вопрос, значит, в сотрудничестве с Министерством юстиции и Управлением пенитенциарной службы проводится систематическая работа с детьми, находящимися в воспитательных учреждениях. Проводятся мероприятия по здоровому образу жизни, встреча с родителями, ведется лекции о правах ребенка. Дети, день открытых дверей и встреча с их ровесниками. Также в настоящее время в учреждении пенитенциарной службы отбывают наказания около 500 женщин. Их семейные проблемы и проблемы, связанные с детьми, находятся на постоянном контроле Комитета по проблемам семьи, женщин, детей. Часть детей, конечно, находится в семьях, в детских учреждениях, а есть дети, которые живут рядом с матерями. Женщины обращаются в комитет, постоянно обращаются в комитет по различным социальным вопросам. Социальные вопросы – это вопросы пенсии, инвалидности и другие. Благодарю за внимание.
I thank you, Madam Gahramanova, for your intervention. And now I wanted to give the floor to Mr. Ilgar Kasimov, Deputy Minister of Health, to address some issues raised yesterday by Madam Anna Raku. Please, you have the floor, sir.
Благодарю, уважаемый председатель, уважаемые члены комитета, дамы и господа. Вначале я хотел бы отметить, что Конституция Азербайджанской Республики и Закон об охране здоровья населения гарантируют каждому равенство прав на охрану здоровья и медико-социальную помощь независимо от расы, этнической принадлежности, религии, языка, пола, происхождения, имущественного и служебного положения, убеждений и политической и социальной принадлежности. Отвечая на вопрос госпожи Рачу по психиатрической клинике номер 1, хотелось бы отметить, что это одна из крупнейших психиатрических клиник с длительной историей, многолетней. И там проводятся ремонтные работы в одном и двух корпусах, которые должны быть закончены в этом году. По поводу усмирительных был вопрос мер. Сегодня при наличии опасности со стороны пациента самому себе и окружающим пациентам, он может изолироваться на короткое время. Никаких механических приспособлений для этого не используется, так как сегодня в Азербайджане, как и во всем мире, имеется лекарственная терапия. По поводу недостатков психиатров, спасибо за вопрос. Это в мире тенденция и в развитых странах. Учитывая, я не хочу отнимать ваше время, но должен констатировать, что профессиональное выгорание психиатров и где-то влияет на недостаток психиатров во всем мире. И Министерство здравоохранения совместно с университетом мы работаем над этим, привлекаем студентов, создаем интерес, повышаем статус психиатров, возможно, и какие-то надбавки региональные, возможно, к заработной плате. Это тоже надо учитывать. И надеемся на определенный сдвиг. При этом Азербайджан участвует в Министерстве здравоохранения совместно Всемирной организацией здравоохранения в программе Mental Health Gap. И, в принципе, мы надеемся улучшить ситуацию с недостатком специалистов немного опустив обращение на первичную, на поликлиническую службу. На поликлиническую службу это используется во многих странах. Также, продолжая тему предыдущего оратора Садегат Ханум, у нас функционирует детский психоневрологический центр, который оказывает медицинскую помощь детям, страдающим заболеванием психоневрологического профиля. В целях обеспечения доступа к медицинским и психологическим услугам для детей с ограниченными возможностями, в том числе и аутистического спектра, Министерство здравоохранения посредством сотрудничества с местными неправительственными организациями, которые являются членами общественного совета, так и по информации, поступившей на детскую горячую линию, телефон 116-111, оперативно предпринимает соответствующие меры. Центр психического здоровья совместно с Университетом Чикаго, США, с 2020 года проводит проект по оказанию психологической помощи и психосоциальной реабилитации детей, возвращающихся в свои семьи из школ и интернатов. До сих пор в рамках проекта аналогичные услуги были оказаны почти 400 семьям. Проект продолжаться будет до 2025 года. Также Центр общественного здоровья и реформ регулярно проводит просветительские мероприятия в социальных сетях с целью снижения стигмы, дискриминации и барьеров в отношении людей с ограниченными возможностями, психическими заболеваниями, как для населения, так и для медицинского персонала. Параллельно отвечая на вопрос госпожи Раку, я хотел бы сказать, что в психиатрической клинике медперсонал каждые 3 месяца проводятся тренинги по взаимоотношениям с пациентом и так далее. В случае нарушения я должен констатировать, что есть закон, правила и нормы этического поведения медработников в Азербайджанской республике, регулируется приказом министра здравоохранения номер 137 об утверждении правил этического поведения врачей и, соответственно, медперсонала с 2011 года. Все жалобы на жестокое обращение в отношении лиц, в том числе детей с умственными нарушениями, в психиатрических учреждениях, являются предметом оперативного разбирательства соответствующего департамента Министерства здравоохранения. Клиника, кстати, подчиняется Министерству здравоохранения. В предыдущие годы на основании этих жалоб лица, допустившие грубое отношение с пациентами, уволены с занимаемой должности. Также необходимо отметить по проблеме у нас в Азербайджане в рамках реализации государственной программы по борьбе с незаконным оборотом наркотических средств, психотропных веществ и их прекурсоров и борьбе с наркоманией 19-24 год Минздрав проводит ряд работ. В Республиканском наркологическом центре начало функционировать отделение амбулаторной реабилитации. Планируется организовать аналогичное отделение в других наркологических медицинских учреждениях страны. Помимо этого, в сотрудничестве с представителями гражданского общества проводится расширение программы заместительной терапии среди потребителей инъекционных наркотиков. На сегодняшний день в городе Баку и в городе Сумгаите существуют эти центры достаточно эффективно и планируется расширение. Также по поводу вопросов по поводу туберкулеза. Принятый в стране закон о борьбе с туберкулезом и также решения, приказы и инструкции Министерства здравоохранения создают нормативно-правовую базу для борьбы с туберкулезом. Также в результате мер, принятых в соответствии со стратегией Всемирной организации здравоохранения по ликвидации туберкулеза, ситуация с туберкулезом стала стабильной, хотя, безусловно, требуются дальнейшие усилия. Министерством здравоохранения определены специализированные больницы для диагностики и лечения лекарственно устойчивых форм туберкулеза. Это одна из проблем, безусловно. Создана полностью оснащенная лабораторная сеть в 5 регионах. Также национальная референс-лаборатория. В результате оснащения данных микробиологической лаборатории современным оборудованием улучшилась диагностика лекарственно устойчивого туберкулеза с помощью экспресс-молекулярных тест-систем. Все больные обеспечиваются противотуберкулезными препаратами 1 и 2 ряда. Также существуют 9-месячные схемы, 6-месячные. Также каждый выявленный больной с туберкулезом имеет возможность немедленно подключаться к необходимому режиму лечения. Должен отметить, что это бесплатно. Для этого в стране есть все необходимые препараты и методы ежемесячного мониторинга лечения. Основным условием является амбулаторное лечение. В процессе лечения больному выдается денежное пособие по больничному листу о временной нетрудоспособности. Далее по проблеме СПИДа, ВИЧ-инфицированных, также государственная программа в Азербайджане, и мы активно работаем и следуем рекомендациям Всемирной организации здравоохранения по принципу «treat all» – лечить каждого. В стране успешный опыт профилактики передачи вируса от матери к ребенку. За последние годы не зафиксированы случаи заражения ребенка от матери. В стране применяются активные шаги по реализации призыва ВОЗ и УНАЙДС 95, 95, 95. То есть 95% больных из зараженных, привлеченные 95, и снижение вирусной нагрузки до неопределяемого уровня 95%, получающих лечение. Также лицам, подвергнувшимся насилию и другим насильственным действиям, вызывающим опасность заражения ВИЧ-инфекцией, проводятся меры по послеконтактной профилактике. Также я должен отметить, в 2023 году Азербайджан сертифицирован Всемирной организацией здравоохранения как страна, свободная от малярии. В заключение отмечу, что мультисекторальный подход к решению задач, поставленных Конвенцией, является основой прерогативой для более эффективной и результативной имплементации. Мы приветствуем усилия Комитета в поддержке стран по достижению столь гуманной цели. Благодарю за внимание.
I thank you, Mr. Deputy Minister, for your extensive information that you share with the members of the committee. And now I ask to take the floor by Mr. Kemal Galijev, head of the Service Investigations Department of the General Prosecutor's Office, to address some points within your competences, and then followed by Mr. Vusal Aliyev, Chief Assistant to the Prosecutor General, to inform the audience on the training activity and to provide some statistical data. Mr. Galidjev, you have the floor, please.
Спасибо, уважаемый господин председатель, уважаемые члены комитета, уважаемые коллеги. Довожу до вашего сведения, что 14 октября 2023 года генеральный прокурор Азербайджанской республики и министр внутренних дел подписали совместный приказ в целях всестороннего обеспечения защиты прав подозреваемых и обвиняемых, своевременного предотвращения пыток и бесчеловечного обращения, а также обеспечения эффективной борьбы с ними. Согласно этому приказу, в связи с производством следственных действий в месте, удаленном от жилого массива, где расположен следственный изолятор, задержанный может быть переведен из следственного изолятора в место временного содержания только в исключительных случаях. Это следственные действия, которые не могут быть произведены в следственном изоляторе. Очная ставка, следственный эксперимент, проверка показаний на месте и так далее. Все следственные действия, которые могут быть произведены в следственном изоляторе с участием арестованных, а также после доставки обвиняемых в изолятор временного содержания, не должны содержаться там без надобности. При наличии соответствующих условий для проведения допросов только в комнате для допросов приняты необходимые меры для обеспечения того, чтобы предварительные допросы подозреваемых и обвиняемых в совершении тяжких и особо тяжких преступлений проводились с использованием видеозаписи, полностью отображающей помещение, где проводится допрос, и очная ставка. Во время видеозаписи от начала до окончания следственных действий, а также участие и фиксации фамилий, званий и обязанностей всех участвующих лиц. Как правило, допросы должны проводиться не более чем двумя лицами, чтобы посторонние не должны находиться в комнате для допроса во время допроса, за исключением лиц, участвующих в целях обеспечения необходимых мер безопасности, что допрос должен производиться не более 2 часов без перерыва, должны быть приняты необходимые меры для обеспечения своевременного проведения расследования фактов пыток или жестокого обращения с подозреваемыми и обвиняемыми. В случае выявления нарушения при составлении протокола осмотра лиц, находящихся в следственных изоляторах и изоляторах временного содержания, неполноты сведений, отраженных в протоколе, а также информирование медицинского персонала, работавшего в тюрьмах и пенитенциарных учреждениях. Независимо от наличия или отсутствия жалобы о пытках и других незаконных действиях должностного лица, в ходе предварительного следствия от лица, подвергшегося пыткам, его родственников или иного другого лица, незамедлительно предоставление в прокуратуре информации о каждом факте, обнаруженном сотрудниками прокуратуры, самими следственными органами, запросов государственных органов и международных организаций, а также опубликованные в средствах массовой информации и направление соответствующих материалов в прокуратуру для расследования с целью недопущения расследования таких сведений и фактов в органах полиции, за исключением служебного расследования. Решением коллегии Генеральной прокуратуры Азербайджанской Республики от 30 июля 2020 года в целях проверки правонарушений, совершенных сотрудниками прокуратуры при исполнении служебных обязанностей на основании правил организации работы Генеральной прокуратуры Азербайджанской Республики в соответствии с пунктом 32 была создана дисциплинарная комиссия Генеральной прокуратуры Азербайджана, которая рассматривает собранные материалы по проверке нарушений исполнительной и трудовой дисциплины. Это специальное учреждение, созданное с целью рассмотрения вопросов о дисциплинарной ответственности работников прокуратуры путем дачи, заключения и применения дисциплинарных взысканий. Эта комиссия рассматривает материалы, собранные в результате служебных проверок или комплексной проверки работников прокуратуры в дисциплинарном производстве на основе принципов законности, коллегиальности, справедливости, беспристрастности и объективности. И по результатам представляет Генеральному прокурору представление. После рассмотрения представления Генеральный прокурор решает вопрос о дисциплинарной ответственности лица, в отношении которого ведется дисциплинарное производство и издает соответствующий приказ. Проверка полученной информации о случаях пыток, унижающих достоинство обращения или наказания в соответствии со статьей 207 Уголовного процессуального кодекса Азербайджанской Республики возложена на управление служебных расследований. Хочу отметить, что в республике на сегодняшний день проверкой такой информации занимается только лишь вот это управление служебных расследований, которое подчиняется только генеральному прокурору. Согласно изменениям, утвержденным этим решением, вот, как я отметил, этим занимается только управление по служебных расследований. После этого я хочу передать слово нашему коллеге, старшему помощнику генерального прокурора, товарищу Алиеву.
Thank you. I'd like to submit a few information regarding the data on cases in which, during the period under review, officials have been disciplined for failing to respect the rights of detainees. From 2020 to 2024, disciplinary proceedings were initiated against 102 prosecution employees for violating the rights of suspects and accused persons, for procrastination and for not properly performing their duties. Of these, 6 individuals were dismissed from their prosecution authorities, 66 employees were reprimanded, 18 were warned, and 12 were removed from their positions. Excluding the prosecution, internal investigations were ordered for 70 individuals from other law enforcement agencies due to violations committed. Additionally, I'd like to give some information regarding the CPT report. A number of cases mentioned in the report adopted at the 111th meeting of the Committee for the Prevention of Torture, Inhuman and Degrading Treatment or Punishment of the Council of Europe, held on July 2023, were reviewed. 2 criminal cases have been initiated pertaining to the mentioned facts under Article 309 of the Criminal Code, which addresses the issue of exceeding official powers, and 1 case has been remanded for further investigation after the decision was annulled. And also regarding the information on training programs in Prosecutor General's office, in recent years, the Science and Education Center of the Prosecutor General's office has conducted numerous educational and enlightening events for the employees of the prosecution and other law enforcement agencies. The trainings primarily focused on the following topics: consideration of modern international practices during the restriction of the right to freedom in the context of criminal prosecution, combating torture and other cruel, inhuman, or degrading treatment or punishment, adherence to legislation, human rights, and civil liberties during operational search activities, the principle of superior protection of children's rights during criminal prosecution, accessibility of women to justice, cases evaluated as gross violations of the right to defense during preliminary investigations, issues arising from international conventions on the elimination of all forms of racial discrimination, application of the principles on effective interviewing for investigations and information gathering based on Mendes principles during the interrogation of individuals. More than 1,300 employees of law enforcement agencies, as well as over 220 newly recruited employees of the prosecution, have participated in these trainings. Thank you.
I sincerely thank you, Mr. Galejev and Mr. Aliyev, for your replies to the some of the questions raised yesterday and for your general contribution to today's meeting. And now I want to give the floor to Mr. Adil Abilev, Head of the International Cooperation Department of the Ministry of Justice, who will address some of the points raised by Mr. Todd Backwold and Anna Raku. He will address some issues related to Article 40 and 293 of the Criminal Court, particularly in the context of severity of the penalties, as well as Article 75 of the same code. He will also refer to the issues of expulsions on the basis of diplomatic assurances. That issue was, in some part, was addressed by the Cengiz Askerev. He will provide some additional information. He also will inform the audience about the issues relating to the Istanbul Protocol, conditions in penitentiary facilities, overcrowding of the prisons, medical staff matters, vocational activity, and children in conflict with law. Mr. Abilev, you have the floor to address all these extensive questions. Please.
Thank you very much, Mr. Sharifov, distinguished chairman, members of the committee, ladies and gentlemen. Mr. Sharifov has already outlined the points, the bullet points that I'm supposed to talk, and that was, as you've heard, very extensive one. But indeed, yesterday, a number of issues raised by the rapporteurs really do fell under the jurisdiction of the Ministry of Justice. So I would like to start with Madame Raku's questions, and I will try to be brief. But yet we still have extensive information to submit. And indeed, as Madame Raku mentioned, Azerbaijan and Moldova, they share a common Soviet legacy, and we understand that these problems with the prison conditions shall be duly addressed. And that is actually on the governmental level, that there is a political will in Azerbaijan to reform the penitentiary. Actually, Azerbaijan was one of the first countries on the post-Soviet era who transferred prisons from the jurisdiction of the Ministry of Interior to the jurisdiction of the Ministry of Justice. And another problem that we faced was that actually the majority of prisons, the vast majority of the prisons, they were located in Baku, in the capital, and it was really difficult for the relatives from the regions to come and see their relatives and so on. So basically, one of the elements of the penitentiary reform was to build new prisons which meet best practices and European standards. The other one was to carry out this work not in the capital but also in the regions, so that the prisoners, they can serve their sentences close to their families, which would further obviously serve to their better social adaptation and reintegration back into the society. In this direction, the number of legislative, institutional, and practical actions have been taken. And when it comes to infrastructure, I would like to say that within the last 3 years, we built new prison for females. So the old prison, number 4, which was cited by Madame Raku, and it was also cited in one of the CPT reports, it ceased to exist, so it's no longer exists anymore. And also we built a new prison for juveniles. That was done both in 2022. In 2023 was built a prison which replaced Kobustan prison, which also reported having not really good conditions. Now we have a new prison, and I would like to specifically add that that prison was built with the recommendations of the CPT. We even asked members of the CPT when they were visiting Azerbaijan to visit this prison, maybe to provide some additional recommendations that we can use while the prison was still under construction, which was done by the members, and later on we used them. And the most modern achievement that Mr. Sharif also mentioned in his opening speech was the introduction of a new mixed regime penitentiary institution in Lankaran. This is the region in the south of Azerbaijan, close to the border with Iran. And it's also a brand new prison and the facility. And another tangible element, tangible example of the political will in this area is that President of our country, while visiting this region, he also specifically went to see the conditions created for prisoners. And it was broadcasted, of course, by TV media and spread with the photos and videos so that all the public in Azerbaijan, they are aware what are the conditions nowadays provided to prisoners. And another thing that Madame Raku mentioned was the problem with the Ganja pretrial detention facility. In this regard, I'd like also to mention that there is a construction of new also penitentiary institution, mixed one, which will absorb pretrial detention facility and the facility itself, so kind of prison is under construction in Ganja. 47% of the construction has already been done, so basically, hopefully, with the proper funding, we can also finish the construction of it within the coming years. And regarding the 4 square meters that you mentioned, Madam Raku, as well. Of course, all these facilities, they provide minimum 4 square meters per person, excluding sanitary facilities. Then I would like to mention another issue that you raised. By the way, we also, along with building new prisons, we're also spending money on repairing of the old ones, including the Shuvalan pretrial detention that you mentioned also, which also located in Baku. Another issue that you mentioned is the staff member. If you look into the reports of the Council of Europe, there is a common problem with the staff members in many countries, including medical doctors, and we also understand this problem. And just for your information, since 2020, the staff number increased by 12% in the penitentiary, including 4% of female staff. And this year we asked also for extra staff, so hopefully we'll get more this year as well. Regarding the issue that was mentioned by the subcommittee of torture while they were visiting Nakhchivan, that you mentioned that there was only one female guard in there. Nowadays, it was easy to check because the facility is not so big and not so many prisoners currently are serving their sentences. So nowadays there are 8 female prison guards. But you also need to take into account there are only 6 female prisoners in there at the moment. Regarding the budget allocations, also, of course, it's a common problem. I mean, when you discuss the issue of allocating money with the Minister of Finance, obviously prisoners are not in the top spot. Yet, Minister of Justice, we are trying to work in this direction. And since 2020, the budget allocated to the penitentiary system and the amount of money allocated per person, per prisoner, both increased by 1.6 times. And also, we have a gradual increase in the quality of the medical assistance in prisons and pre-trial detention facilities. As Mr. Askarov mentioned earlier, when it is needed, we can invite medical doctors from civil sector. We can send the particular person outside to the civil sector hospital to carry out specific surgery, which is, for instance, not possible to be carried out inside the prison facility, or if a person wants a specific surgeon or doctor to carry out this operation. I would like to specifically mention the fighting TB in prisons, because I believe that we have some developments that are worth to be shared. And it's not our opinion, it's the opinion of the ICRC and the Global Fund, which we have been working for many, many years. We started to address this problem since 1995. And at that time, it was really a huge challenge for those who were sentenced, because, as you mentioned, the old barrack type prison, it's really provides a huge risk of TB to be spread drastically. According to the World Health Organization analysis, the risk of the TB to be spread inside the prisons is 100 times higher than in the civil sector. So we started to work with the ICRC, and just in kind of bullet points, I will try to highlight the developments, the achievements that we have at the moment. First of all, when a person arrives to a prison, we have a Gen Expert equipment, which helps to test a person in 100 minutes that whether a person is infected with TB or not. Then since 2009, we not only treat prisoners inside the prison, but also we follow up once they are released, but the medical treatment is not over. We still do the follow-up once they are free in the freedom. And we also cooperate in this area with various NGOs. Just to figure out the results that we reached, if the WHO sets the 90% threshold for the positive treatment of normal TB, we have 96%. When it comes to multi-resistant form of tuberculosis, it's the 85% according to the World Health Organization, whereas we have 88. And just for you to compare, if you compare the number of deaths in prison since 1995 and 2023, the death rate went down by 169 times. 169 times. When you compare 2013 with 2023, it's 3 times less. And just for you, as an example, last year we had only 8 cases, 8 deaths out of the tuberculosis, but all of them, they were aggravated by the other diseases like HIV and hepatitis. Thanks to these results, positive results, World Health Organization since 2014 established the Collaborating Center for TB Control in Prisons in Baku, just very close aside to the special medical facilities for TB prisoners. And it's got international status. It was 2 times prolonged, last time in 2022, for extra 4 years. So what the center does, it provides training for TB control in prison system from different countries. Since its establishment, we had around 200 training activities, which were joined by 2,600 of participants from Africa, Asia, Europe, and even South America. Representatives of 21 states visited our TB facility and this center to study the best practices we've got, including representatives, not only the Minister of Justice, but also the Minister of Interior, Minister of Health, and representatives of the civil sector. And I would like to know that some of the countries, they are represented also here, like we have the visitors from Moldova, China, Turkey, and many others. Regarding the psychological care in psychiatric care in prison, it's really an issue, and it's not only, as our Deputy Minister of Health mentioned, that it's a common challenge, not only in prisons, but also in the civil sector. We have very good assistance with the Council of Europe, with the European Union. We had a number of projects held together on training in this area. We had even Turkish psychiatric professors visiting Azerbaijan to do training of trainers. So we're also understanding the problem. We're working in this area as well. Regarding another issue on the alternative measures, as you rightly mentioned, we had a decree of the President dated 2017, which set up a number of actions and tasks to be done in terms of the reducing overcrowding and applying alternative sanctions. Since then, we had a probation service established in Azerbaijan. So the decree was dated 2017. In 2018, the probation service was established. We started best practices with different countries, even our neighbors and some others, to see how fast we can let this service grow. Because, to be honest, in some countries, the probation services were at first stage only allowed to minors. In some countries, it can only be done voluntarily. So the accused persons, they were kind of getting an option whether to go to prison for a less number of years, like let's say for a year, or 2 years in probation, and they were choosing prison instead. Just a couple of figures. Since the establishment of the probation service, we used around 20,000 bracelets. Because according to the change into the legislation, we had introduced a new sanction, limitation of liberty, and the bracelets, this electronic monitoring, is being used for this particular execution, for this particular punishment. Apart from that, the probation officers, they're dealing with community works, with the correction works, with fines and so on. So currently our probation service has under supervision a bit over than 24,000 persons. Apart from that, as an element of the humanization of the legislation in Azerbaijan, we had like 3 stages, 2017, 2018, and the last one, 2020. A number of, over about like 35 crimes, they were decriminalized. Some crimes had their sanctions increased, so that that really affected the prison population in terms of reviewing their sentences and even releasing a number of people. And just for your information, due to these reforms, about 6,000 prisoners, they were released, they were covered, including 1,216 were released in 2020. Also, we are widely using release on parole. We never stopped doing that even during the COVID period, making benefit of the video conferencing equipment that are provided in all of our facilities, so that court proceedings can go on, and this very equipment helps us to do the interviews. We have a special commission on the parole, which also, among officers of the Minister of Justice, they also include members of the NGO. And since 2020, about 11,000 prisoners they were released on parole. So within these 4 years. Amongst these other things, also, as Minister Sharifov mentioned, amnesties and pardon acts in Azerbaijan is a kind of widespread practice. We had 2,700 persons released from prisons following the amnesty, and 1,385 persons were pardoned. And also, just for your information, normally in May we have an Independence Day, the holiday in Azerbaijan, and normally at this stage we also are expecting a new pardon decree. Also, another issue that we recently started to introduce is the restorative justice, because in 2022 there was a conference of the European Ministers of Justice in Venice, which was devoted specifically to this very issue. So we started to work on this area, and we even became a member of the European Forum on the restorative justice, and we also work with the social services agency. I will not elaborate on this issue because we have a colleague in our delegation who will further on also speak about this very thing that we're doing. But also a couple of points that I would like to note that Madam Rako mentioned. Regarding the juveniles, we are now stopped the practice of using the solitary confinement in the juvenile facility. It was actually also the recommendation of the CPT, and now we drafted an amendment to the legislation to abolish it by law. Also, as during the last visit of CPT to Azerbaijan, during the meeting, I'm not like exposing the report, but during the meeting at the ministry, members of the CPT who visited female prison and juvenile prison, they said that they had no single allegation. They didn't hear any single allegation about the torture facts in these two institutions. We also started, since using the IT, as I said, apart from the video conferencing, we started to use, and we changed the legislation to allow prisoners to use video meeting with their relatives for 15 minutes, and also providing 7 days vacations, depending on the behavior of the prisoner, of course. And when it comes to juveniles and females, we have a number of projects with the UNICEF, with a number of NGOs inside the prison regarding their vocational training and so on. Interesting point for me, as for instance, the person who is fond of football, many prisoners from, not many, there are only actually 26 juveniles in the juvenile prison at the moment. They go out to watch football games. We arranged even a game with the junior team of our best team, Karabakh, which qualified to the quarterfinals of the Europa League. So they had a game inside the prison with the junior team of this game, which was fun, which was very interesting, and I think they were honored to meet with these people. When it comes, they also have computer classes, language classes, but I believe this is a common practice. And as Madame Gaharmanova also mentioned, we have open doors practice in both of these prisons. When they can meet their relatives, their peers, they do some other activities together. And also, when it comes to females separately, I'd like to know that we are now working with the several entrepreneurs to provide, to ensure that these persons, when they're released, they can find proper jobs. So, for instance, with a number of cleaning companies, we have a certificate-based training on the cleaning, and some of females who were released already, they are now working in several hotels doing cleaning, for instance. Chefs also from several top restaurants in Azerbaijan, in Baku, basically the capital, they do training on cooking for many people, and then also some of them are later on recruited after their release. Females even have their own music band, which was widely broadcasted on TV as well. When it comes to the training activities, of course, it's very important to do the training, including the Istanbul Protocol. As you mentioned, Madam Rako, yes, indeed, training on the Istanbul Protocol, especially for members of our medical service, is mandatory. Within this period, since 2020, we had 10 trainings for about 120 medical staff, including over 500 other professionals, like lawyers, and 122 judges and 231 candidates. The difference between training for judges and the candidates is that training for judges is voluntary, because we can't force a judge to go for a training. When it comes to judicial candidates, it's included in their curricula. So basically, I believe that's it when it comes to the questions of raised by Madam Rako. When it comes to several legislative issues raised by Mr. Buchwald, I would like to note that indeed, as Mr. Buchwald suspected, when it comes to Article 40 of the Criminal Code, it is indeed a translation problem. And the word obviously is not really reflecting the wording of the article. So basically, it should sound like, let me quote the translation. The person who committed a deliberate crime by execution of illegal order or instruction, which he knew it is illegal or he should have known it is illegal, shall carry out the criminal responsibility in accordance with the general grounds. So it's not obviously, no one is deciding on this issue whether it's legitimate or not. When it comes to Article 293, regarding the definition of torture, I would like to know that in the first paragraph, the article speaks about the harm not reaching the torture threshold. But when it comes to the sanction, it's, well, one might say that it's a subjective view that the sanction is not that high, but if you look into the other criminal sanctions in the criminal code, like, for instance, murder by negligence or murder in the state of affect, it's almost the same sanction. However, when it comes to torture, in the paragraph 2, the sanction reaches maximum of 8 years, which according to our legislation, based on the severity level, comes under the understanding of the serious crime. For us, when the sanction is over 7 years, it means that the crime is serious. And therefore, it should be considered by a serious crimes court and not even an ordinary court. When it comes to the Article 75 on the lapse of time, well, indeed, it does apply to the torture article. However, if you look into this paragraph 3 of this article, it says that if person is hiding from the investigation, the time flow shall be suspended. So basically, in practice, if the person is hiding, is fugitive or running away, it's not counted. So 12 years period for this particular type of crime, it's not applicable in this particular case. Regarding the extradition, I believe I am reaching the time limit, but I still have some information regarding extradition and diplomatic assurances, so it's up to you, Chair, to decide whether should I continue or I can come back after the break.
Thank you, Mr. Abilev, for your detailed information. Of course, we have some issues which we know that you wanted to share with the audience, but we are in the hands of our chair to decide whether we have a couple of minutes that you will finish your statement, or it's okay. You can finish on diplomatic assurance. Okay. Thank you.
Thank you very much. Well, when it comes to, sorry taking your break time, but yet, I mean, I'd like to raise a couple of issues regarding the diplomatic assurances. Indeed, not only in expulsion cases, but also in extradition cases dealt by the court in Azerbaijan, we do use diplomatic assurances. And basically, that goes both sides. So, which means we require, when we see that there's might be a risk that the surrender of person or extradition of a person can be resulted in torture, we do require diplomatic assurances. And we do sometimes ask even for post-extradition monitoring by our consular services. Or we ask from our partners the follow-up information after the surrender. For instance, just for your information, within this period of time, since 2020, we rejected extradition in 2 cases to Iran because of human rights situation in Iran regarding these particular persons. One actually was of Azerbaijani origin, sorry. He was Iranian national, but original Azerbaijani. And one case was regarding the rejection of his extradition to Oman of a Pakistani national. When it comes to us also, we, in one case of the extradition to Thailand, of a person who was suspected in the human trafficking, national of Uzbekistan, we required the assurances. Only after that, we surrendered this person, but yet we asked later on our Thai partners to provide the follow-up information of this person. And the same case we had with India, when we extradited a person to India, according to the bilateral treaty, we not only asked for a general, human rights and torture assurances, but also there was a risk that a person could be sentenced to a death penalty because that was a murder case. So we asked specific guarantees that death penalty in this particular case would not be executed as well. So basically, that's what we do while we consider extradition requests. Also, just one more minute of your time. We had a couple of fact-finding missions coming from different countries during the extradition proceedings, namely Germany and UK, who came to see our pretrial detention facilities and the prisons, so that to make sure that the extradition of this particular person, the fugitive, would not violate his or her human rights. In both cases, the defense, they didn't get anything, so the reports were positive. And after that, we got extradition from both of the states. But it's not a common practice as far as I know, and not all states do allow this kind of fact-finding missions to come and see their prison facilities. However, taking into account the interests of Azerbaijan, first, on one hand, fighting serious crimes, and on the other hand, being balanced in terms of ensuring human rights, we did that on our own intention. Thank you very much.
Muchas gracias. Agradezco a la delegación sus comentarios y respuestas a un buen número de preguntas que fueron formuladas el día de ayer. Y para seguir con este diálogo interactivo, le voy a ofrecer nuevamente la palabra a los relatores. Tiene la palabra el señor Buchwald.
Thank you, Mr. Chairman. Thank you, Deputy Minister, and thank you for your delegation. There was a lot of information. It will take a little time to process some of it, but it's very important and very, very sort of useful. I was going to go through sort of in tick point form a little bit, just to sort of get the questions out there, or some questions out there on I don't think I heard an answer to the question about whether you would consider releasing the European Committee on the Prevention of Torture and its report and our subcommittee's report. And it might not seem like the most important question in the world, but I think it actually is an important question because it goes to the issue of promoting transparency, having people have confidence that you're sort of being open and not sweeping things under the rug. And I think there could be a lot of benefit in doing that. And I don't know what's in them, and I'm sure there's criticism, but the criticism is part of the what's the word that the phrase that sunlight is the best disinfectant. Every one of those European Committee reports will have criticism in it, and it'll be, in my opinion, it'll be an important step forward to allow for its publication. The sort of a little bit in the same vein, we had asked for statistical information on NGO registrations, and I know we had asked a lot of questions and you couldn't answer them all in the allotted time, but I think we had asked for year-by-year information on the number of NGOs that were registered since your last report, how many were denied, the grounds for denial, this kind of thing. And if it's possible, I think at the end of this, the chairman will say there's 48 hours of possibility of getting more information. If it's possible to get that information, I think that would be very, very helpful also. On the, I did have one question from your opening statement yesterday, which was an excellent opening statement. And I read it again overnight. And it had the section on the, it says 705 police officers were subjected to disciplinary responsibility, and it sort of went on to say, for bringing citizens to the police offices without substantial reasons and their illegal detention. And then it said, as well as for rude and other degrading treatment. And it caught my eye because I've seen that phrase in other, rude treatment is, I'm wondering if that's a translation. What does that mean, rude treatment? Is that torture, not torture, Article 16 violations? It's just not a phrase that I'm used to hearing, but I've seen it in other documents about Azerbaijan, so I think it must have a meaning to you that isn't quite coming across in translation. So if you could clarify that. On the, on my question yesterday about the ICC, it's an important question. The ICC could be a sensitive issue for a lot of countries, but it's an important issue in the same kind of way, of in the sort of spirit of transparency. The as I said yesterday, I'm sitting here in Geneva. I'm getting information secondhand, including from you all, right? I'm hearing there's these investigations, that investigations, and it's not it's not sort of forensic kind of information. And the thing about the ICC is it comes in and it does real work. Rarely, very few cases that are actually prosecuted, but it does real work. And it's in the spirit of, sunlight is the best disinfectant. I think it will be sort of a useful and positive step. And you're in a position where the other side is saying, come on in. And, it will, I think, be to your, hopefully, you'll see it as to your benefit if you can either become a party, accept the jurisdiction, or promote its work in some way. I think that would be a positive step. I'm sort of going through my list from yesterday. Mr. Askarov said that anyone who's ill-treated has a right to a remedy. I had asked yesterday about a particular version of that question, which was about Armenian POWs. Do they have a right to pursue a claim in Azerbaijani court that they've been abused? Has anyone done it and won? And to do it, would you have to hire an Azerbaijani lawyer? So I don't know if it's possible to provide that information, but that would be interesting for me. And I also don't think you got around to, and I know the time is short, but the cases about the renditions of, where like our A and B, the case before our committee, the A and B case, where the person, and cases where the person was, went to court, the court said don't extradite him, and then the next thing he's sort of gone, the Hizmet cases. So if you have information on that or a reaction to it or steps that have been taken to, guard against recurrence or whatever it is. And then also, I think at the time, connected with that question, I'd asked a question about, right, so the A and B case, the case before our committee, involved also interim measures, right, that we had requested, which I think most countries regard as binding. So this person, we'd asked for interim measures, and the person was sort of rendered in that period when the interim measures were out there. So if you can, sort of provide information on how you all deal with a request for interim measures firms. How do you deal with our recommendations? You have a process that it goes through. Who's making the decision? Where I assume it goes from us to your mission, from your mission to Baku, and to Baku. There must be some process for dealing with this, and how is it dealt with? And actually, do you? I mean, it may be that you don't believe that there's a legal obligation. I mean, that's it's. I'm just trying to get more information about how you process all that and think about all that. There are a couple more questions, but I think that that's more than. Oh, I was going to ask one particular question, which is, so the discussion yesterday, the 23 people, right? Some say they're POW, some say they're not POW, whatever. The 23 people that remain, I think it's actually a much harder question. And I'm sure you've studied it more than I have, but to me, it's a much harder question than they were captured after the war ended. That's not the be-all and end-all of the analysis. And, if you, and especially when the question is whether they're terrorists, and I think the statement yesterday was they're terrorists in accordance with international conventions. And I don't think that's correct. I think there is no one single international terrorism convention. The one that's the closest, which is that will probably apply here, is the Terrorist Bombing Convention, and it specifically says that if you're military, you're not covered by it at all, no matter what. So it is sort of a complicated question, and it's way too much to go through, here this afternoon for sure. But I was wondering whether, besides the 23 that are still held, there were more people there before, and who were they, and who was returned, and what was the rationale for returning them? Presumably, they were picked up on the same kind of terrorism charges. So how did it end up that these 23 are still held? I don't know how many there were originally. What were the circumstances of their return? These kind of things I think would help me process what to make of what's going on. And if I could, well, just in really big tick points, the questions I was going to ask yesterday, one was about compilation of statistical data. And the short version of the question is, there were a lot of questions in our list of issues prior to reporting, and then your report, where we asked for statistical data, and it really wasn't there. I mean, in fairness, it really wasn't there. And, my point today is not to say that in criticism. My point today is to sort of ask if you is there, to us it's very important, and our view is it's important to you, to countries that, to compile it, and are there prospects for enhancing your ability to compile it and analyze it? Because I think the compilation and analysis of statistical data is a great way to sort of ferret out where problems are that aren't really being foreseen, appreciated. It reveals all kinds of, it's, oh my God, there's 27 cases over there and none over here. I think it's a really valuable transparency, a step forward on transparency. And then, I did want to ask about one other topic, which was LGBTI persons. And there are lots of sort of issues, right? And there's lots of criticisms that have been out there, that there are no laws on the books specifically protecting them, that there are hate crimes that are not prosecuted and so forth. There's a lot of online sort of hate that's not moderated, and that the police themselves sometimes are abuse such people, and so forth. So it's a question that really deserves a lot more explanation than I just gave it, but I think you get the gist of it. If you have any thoughts on what's being done to sort of deal with this set of problems, it would be really helpful for us. And so with that, I have abused my time, and thank you, Mr. Chairman.
Muchas gracias, señor Buchwald. Y le ofrezco la palabra a la señora Ana Raku.
Thank you, Chair. Distinguished member of the delegation, welcome to the second round of our dialogue. I would like to thank you for your replies and for the figures provided to the committee. I listened carefully to your answers and comments and views, but there are some additional questions that I want to raise during this dialogue. The first one refers to children in conflict with the law. Thank you for the details on the provision of the national legislation concerning children in conflict with the law, including provision on interrogation procedure, educational programs offered to minors, and of course the update on solitary confinement for juveniles. But yesterday questions on juveniles in detention referred also to the following issues: complaints mechanism available for children behind the bars, as well as monitoring visits carried out to the juvenile detention center by relevant bodies, and specific findings or recommendations made by such bodies. We will appreciate your replies either now during the dialogue or later in writing. Excessive use of force in places of detention and death in custody. Regarding death in custody, we appreciate the details regarding the number of suicides. If I understood correctly, no criminal investigation has been initiated on any of these cases. And we would like to hear more information about these cases. When the committee requests information on the death in custody, it refers to all death in custody, including those related to natural causes, recording during the reporting period. We are still interested to receive statistical data on the number of all death in custody and measures taken by the state party to prevent death in custody, including suicides and violent incidents among detainees. Also, yesterday I asked several questions about the use of physical force, firearms, and special means, including cases of excessive or disproportionate use of force and special means in correctional facilities. So I would appreciate your comments and data on the following questions. We want to receive a statistic on the use of physical force and special means by prison staff towards prisoners. Please also provide us with the number of cases related to guards that have been disciplined for excessive use of force. And also, please provide information, any relevant internal guidelines or provision that regulate the use of force and special means within prison setting. On women in detention, we appreciate your comments and additional information. What we haven't heard are the information about newly built prison, especially regarding the access to medical care and hygiene products for women, and employment and educational programs available in the new prison. I would like also to hear some information regarding detention regime and conditions for convicted mothers with children. Now, on other important topics such as health in prisons. On this specific subject, I would have a few additional questions which would help us to better understand and assess the situation regarding the access to medical care in correctional facilities. What are the exact procedures or protocols in place once a medical professional finds and documents injuries resulting from violence, ill treatment, or torture, or other incidents. Also, please provide us an update on the measures taken to provide medical equipment and medicines to pretrial detention institutions and prison, which apparently seems to be problematic, at least in some of the institutions. We are grateful for the information concerning measures taken in order to prevent and control and treat the infectious diseases, including tuberculosis. You have seemingly a very impressive structure set up for tackling TB. Can you please describe a little bit more how this would work for, in practice for a detainee? Do they need any documentation or a court order to be transferred from a prison detention center to a special hospital or a prison hospital? Also, I'm interested to know what are the procedures in place for those who refuse such treatment. I'm referring to TB and HIV treatment. Concerning condition of detention, I would like to thank you for the details regarding construction new prisons, also the update on the correctional staff and current refurbishments in the penitentiary system of Azerbaijan. I want to reiterate some questions on the situation in pretrial detention units. So we want to hear what exact measures have been taken by the government in order to improve the detention conditions in pretrial institutions, which allegedly have the most difficult conditions and are, according to some of the reports, are the most overcrowded. What steps have been taken in order to improve the situation of vulnerable categories of prisoners, such as lifers, prisoners convicted to life imprisonment, prisoners with physical and mental disabilities, and elderly. On solitary confinement, yesterday I asked some questions concerning appeal procedure for placement in solitary confinement, duration and categories of prisoners on whom solitary confinement is most often applied. And today we received just a very positive update only for the minors. So we invite you to elaborate a little bit more on the disciplinary sanctions applied to prisoners, including solitary confinement. On psychiatric establishments, we would like to thank you for the information provided, but I would like to clarify some statements. Is it correct to understand that mechanical restraints are illegal in the state party? If so, could you please point me to the regulation or legislation where this is laid out? If not, could you please specify the similar regulation or legislation for chemical restraints? Yesterday, I asked specifically about legal provision practices as well as mechanism to appeal involuntary situation or cases of involuntary placement in psychiatric institution, and how often does review of placement take place, and how this process is conducted. And your comments would be appreciated. On my last question refer to investigation of ill treatment and torture cases. We would like to thank you for the information provided about investigations and prosecutions. We still have some additional questions. What are the exact number of complaints of torture and ill treatment received in total, both by Ombudsperson and Prosecutor Office? How many investigation, prosecution, convictions in total? And what provision of the criminal code are perpetrated, convicted under? In addition, we want to clarify if an investigation into torture or, let's say, domestic or gender-based violence be conducted ex officio in the absence of a complaint of the victim. If you have such figures, please provide it to us. Also, we want to receive more information on how the state party is implementing its obligation under Article 14 of the Convention. Could you please provide more information regarding the number of victims of ill treatment or torture who have received compensation during the reporting periods and the amount received? Also, we want to hear if victims have access to means of redress and rehabilitation or public apologies or other remedies available in the country. And in advance, I would like to thank you for the information and data provided to our questions and comments.
Muchas gracias, señora Raku. Y pregunto si algún otro miembro del comité desea tomar la palabra. Señor Iscan.
Thank you, Chair. Thank you, Minister, and the delegation for having actively engaged in a dialogue with the committee. As Mr. Buchwald said, we have had abundant information to process, which we will do in due time. I have one additional point to raise. If that is already answered, I regret to have missed it owing to my concurrent engagements. But anyhow, I will raise it. I have noted the amendments made in 2022 to the Code on Execution of Judgments. If my understanding is correct, the amendments aim at allowing the prisoners to have video meetings in addition to phone calls. This constitutes a positive step if the required infrastructure could be made available and if it is applied effectively and without discrimination. Has this amendment been in effect? If so, could you elaborate on the outcome in practice? Thank you, sir.
Gracias. ¿Algún otro miembro desea intervenir? De no ser el caso, le doy nuevamente la palabra al señor viceministro.
Thank you, Mr. Chair, and I thank the members of the committee for the second round of questions that raised was regarding to the statements and contributions made by our delegations following yesterday's discussions. We are witnessing from one side that some of the questions that was raised today, it was a repetition of the questions that was addressed in some way by our delegations. I wanted to refer to the issue of the new renovated prisoners facilities. Actually, I referred in my initial statements and gave plenty of information about the facilities and conditions and the work done in these facilities. And today, the representative of the Ministry of Justice already addressed this issue. We also witnessed that some of the statistical data that was requested was addressed in the introduction statements by the Ministry of Interior and other delegations. But nonetheless, we will try to go through these questions. I would like to first start with the questions raised by Mr. Todd Backwold. You referred to the word crude treatment. Maybe it was heard in or stated a little bit incorrectly, but I can assure you it was in a context of ill treatment, not any other meaning in the cruel treatment. With regard to the publication of the reports, actually that is not a matter for the government to avoid any criticism. If you will look at the practice we had before, the government always was in a position to openly work with the committee, and many reports was published previously. But it's a matter of choice that the government is position whether to publish or not, and we took note your request for the government to publish it. We will duly consider this interest of the committee for publishing the reports. On the matter of registration of NGOs, yesterday when that question was raised, I already told that some of the questions was not fall to the competences of the committee. And I said that the matter of the new law on media and the registration of the NGOs, this is not a matter of the committee's mandate, and we provided all this information under the other treaty bodies mechanisms. And if you want, of course, to the information to be discussed within this committee as well, of course, we will provide it in writing to you, all the information that we already shared with under the other mechanisms. Concerning the International Court of Justice, you are maybe know better than others that the international crimes yesterday the question was raised about the Azerbaijan's interest in the work with the International Criminal Court, and the issue that whether we are ready to cooperate with the International Criminal Court on the matters. And you all know that the international crimes that fall under the jurisdiction of the court, all these crimes was committed against my country during the 30 years of aggression and occupation, and Azerbaijan is one of the country who advocated for the long period of time of avoiding the impunity for the criminals who are committing these international crimes. But at the same time, Azerbaijan is still considering and closely monitoring the work of the International Criminal Court, and for time being, I think that it will be difficult for me to announce any issues, but when any decision will be adopted in due course, the committee will be informed about that. I think that on LGBT, I just wanted to draw your attention that all citizens in the country are equal before the law, and Azerbaijan guarantees the rights of all the citizens without any distinction as to the sexual orientation or any others. And we don't have the division of our society on these categories. So the category of persons are the citizens of Azerbaijan, and they fall under the jurisdiction of the constitution and other legislation in equal to with other citizens of the Republic of Azerbaijan. On other issues, I think that I can maybe give to give the floor to the deputy head of the Supreme Court, Mr. Chingiz Askaryev, for giving some additional clarifications, please.
Thank you, Ms. Sharifov. I'll try to be brief. Coming back to the question which I addressed yesterday, I don't want to go into the legal debates here, but when we speak prisoners of war, these are individuals who were captured during the military hostilities. These 23 individuals which you referred to, Mr. Buchwald, they were individuals of Armenian origin, nationals of the Republic of Armenia, captured some 150 kilometers from the Armenian Azerbaijani border inside the sovereign territory of Azerbaijan. And 1 month after the ceasefire trilateral agreement, and they cannot be regarded prisoners of war, no way. Accordingly, they were treated as civilian prisoners, and even before the European Court of Human Rights, these cases are there, proceedings are being undergone before the European Court of Human Rights. They not be referred to as prisoners of war, but just ordinary civilian prisoners. All of them, all of the foreigners, they are being insured with the legal assistance and with the interpreter. Recently, I would just, for example, tell you that recently, within the communication with the European Court of Human Rights concerning the cases of individuals of Armenian origin and Armenian nationality, we sent a bundle of some 50,000 pages of materials of criminal proceedings in Armenian language. That means that all of them are being provided with the legal assistance and with the interpreter. And they are being insured with the right to access to justice. We didn't receive in the internal proceedings any complaints of Armenians to ill treatment or torture, and that's therefore I cannot give you any example of examination of their complaints on this point. Concerning the question of them being charged with the crime of terrorism, it's only charge. It's not the case. It is not brought to the court. They are not being tried. According to the legislation of Azerbaijan, the court is not bounded by the Indictment Act and can interpret the crime committed on its own. And therefore, even if we now see that they are being indicted or charged with the act of terrorism, it is up to the court, the national court, to sentence them or to acquit them on that crime. And concerning the LGBT, if I may add, there is no limitation on, as Mr. Sharif told, limitation in the legislation on the sexual orientation. And recently, before the European Court of Human Rights, there were a decision on concerning the case of some 25 representatives of LGBTI community in Azerbaijan. The case referred to the events happened some 6 years ago concerning these individuals, the administrative arrest, and the government of Azerbaijan submitted to the court the unilateral declaration acknowledging their violation of the rights of these individuals, and therefore the court accepted this unilateral declaration and declared the case inadmissible. but I bring this example to say that this was the only one case that was some 6 years ago, and after that, the law enforcement agency they were not faced with such events or detention of representatives of LGBTI community because of their sexual orientation. Thank you.
I thank you, Mr. Askerov, and I just wanted to give the floor to Mr. Adel Abilov from the Minister of Justice. Please, you have the floor.
Thank you, Mr. Sharifov. Just a quick reaction. Well, to be honest, it was a time constraint, so I was going to address a couple of issues later on, but yet just going through the questions regarding the monitoring of the facility for juveniles. It's not only this facility, but it's all the facilities under the jurisdiction of the Ministry of Justice that we have specifically, as Mr. Sharifov also mentioned in his opening statement, since 2006, a public committee, it used to be called public committee, now it's public council, which is formed of the prominent NGO activists that have a specific group which can visit anytime any penitentiary facility without prior notification to the Minister of Justice. They get a specific mandate as CPT members from the Minister of Justice, so that just showing this mandate they can enter any facility. They come up with a specific reports which they later on send to the Minister of Justice, not to the Penitentiary Service, but to the Minister of Justice, to the Minister, to be reported to Minister directly, so that then actions and following instructions would be sent to the Penitentiary Service. Regarding the specific question that whether we have a kind of guidelines on the excessive use of force, indeed, yes, we do. We do have these guidelines, and in 2022, following up the CPT visit, we even amended these guidelines following the recommendations. But basically, these guidelines are based on the CPT standards, but yet it's still being improved following the recommendations of the CPT. Then, when it comes to the women in detention, basically, as also has been mentioned yesterday and today, we have, there is only one separate penitentiary facility for females, which has been newly built. So, of course, it's a mixed regime. The only thing that, according to our legislation, women cannot be sentenced to life imprisonment. So basically, it's a mixed regime. There are different blocks, and they are detained according to the regime provided by the court sentence. When it comes to the mothers with children, just yesterday I checked with the Penitentiary Service. There are only 3 mothers at the moment who have kids under 3 years old, who are, of course, with their mothers. However, when it comes to these mothers, they have a separate conditions, separate cells, that, and with the playing ground and playing rooms, specifically for these kids. And also they have extra rights to get extra visits. When it comes to the protocols registering traces of torture, I mean, of course, the Istanbul Protocol that I also mentioned, we have our officers trained mandatory in this particular area. The procedure is that whenever a person enters the facility under the jurisdiction of the pretrial detention facility, the member of the medical staff, so not a penitentiary officer, member of the medical staff, they are not subordinate to a penitentiary system. The whole department is subordinate directly to Minister himself. So they do, they do the recording. They do the recording, and then if there are traces, this is suspicion regarding the traces like followed up by torture, then they send it to a prosecution service. So that's the protocol that they follow. When it comes to medical care in pretrial, specifically also coming to women, again, the following the recommendations, by the CPT, we have a specific decision by the Cabinet of Ministers that provides elementary needs like hygienic packs, and especially for females with kids like Pampers and so on. The amount of money allocated in this decision was increased substantively. It was done. Let me just check whether I can get the. I think it was done in 2022 or 2023. I might be mistaken. And when it comes to just next question. When it comes to the transfer to if the person is sick or diagnosed with TB or HIV, then it's just our medical department submits the list to the penitentiary service, and penitentiary service does the transfer. When it's an urgent case, it is done without submission any list, just discussed orally. However, I'm afraid we haven't had the cases of when the person diagnosed with this disease rejected the medical treatment, so I can't provide you information with that. When it comes to, when you mentioned the overcrowding, the pretrial detention facilities, actually, these two new facilities that I mentioned in Umbaki and Lankaran, they do have separate blocks, each 700 with a 700 capacity. For pretrial detainees. So that was the idea, to reduce the overcrowding in pretrial detention. So we have two new pretrial detentions. One, it's very close to Baku. The other one is in the region. When it comes to lifers, the same goes for lifers as well. As I said, Gobustan prison, where the only actual prison with a prison regime, facility with a prison regime in Azerbaijan, it was closed, and lifers were moved to a new prison in Umbaki, so which CPT members visited while this facility was under construction. When it comes to the appeal procedure on putting into solitary confinement, the person, the subject of this procedure, he can appeal to prison director, to penitentiary service, and to the court as well. So he's free to do one of these three options. So I think I mostly covered the questions by Madame Raku. And when it comes to the question of our colleague from Turkey, yes, indeed. The good thing about COVID, if I might say, is that it really did push the development of IT technology in all places, including, and prisons are no exception. So with us, we have, first we started with the establishing video conferencing equipment to make sure courts can proceed without delay. Then this is the same actually equipment which is being used for video meetings. So at the moment it's widely used, especially when the relatives are supposed to travel like 100, 200 kilometers to see his relatives, so they sometimes prefer to have this video meeting. Thank you very much.
Thank you, Mr. Abilov, for giving additional clarifications. Now I wanted to return floor to Mr. Fazil Guliyev. Then I think that I will return back the floor to Chingiz Askerev, the deputy head of the Supreme Court. Please.
Yes, I've been asked to explain what does it mean, the root treatment, Mr. Bakval. So it's, as far as I understand, it is the treatment which even does not attain the level of ill treatment. It means unethical behavior of police officer towards an individual. That means, for example, shouting improper remarks or even refusal to assist an individual. It is factually, in fact, it means that we can call it like a breach of code of ethics. Thank you.
I thank you, Mr. Askerev. I think that I wanted to give the floor now to Mr. Elgar Gasimov for giving some replies to the questions related to your competences raised by the Madame Raku on the chemical medicines and something.
Благодарю. У меня встречный вопрос. Механическая фиксация, это речь идет, госпожа Рау, об усмирительных рубашках или о фиксации кровати? Я вот,
Can I reply? By mechanical restraints, I was referring to the use of beds and belts during specific situation when the patients are have a specific behavior, including aggressive one.
благодарю. Я откровенно вчера не понял вопроса, думал, речь идет об усмирительных рубашках. Провел информацию, анализ. Мне сказали, лет 50-60 мы не используем в Азербайджане усмирительные рубашки. То, что касается фиксации к столу или в транспортировке пациента в состоянии, агрессивном состоянии в скорой помощи, безусловно, там может использоваться кратковременная фиксация мягкими ремнями. Однако в стационаре проводится беседа, если пациент слышит и входит в контакт. Далее разъясняется, в случае отказа и агрессивного поведения фиксация при помощи медперсонала, чтобы провести инъекцию. И кратковременная фиксация в течение до часа. Это вносится в журнал обязательно. В некоторых случаях это используется. Потому что если пациент до инъекции. Благодарю.
Mr. Chair, we had some speakers from the first round of speeches, and if the time allows, because they also wanted to address some questions that was raised yesterday, and with your permission, if you will allow me, I will give the floor to those delegations. Then I would like to give the floor to Mr. Vahid Kahramanov, head of the Department for Migration Policy and Legal Support of the State of Migration Services, to address the issues of refugees, expulsions, and deportations, as it was raised yesterday. You have the floor, please.
Спасибо, господин Шарипов. Ходатайство лиц, желающих получить статус беженца в Азербайджанской республике, рассматривается в рамках требований Конвенции 1951 года о статусе беженцев и протоколом 1967 года, а также законом Азербайджанской республики о статусе беженцев и вынужденных переселенцев, лиц, перемещенных в пределах страны, и порядком рассмотрения ходатайства о предоставлении статуса беженца, утвержденным соответствующим указом, нормы которых соответствуют перечисленным международным документам. Ни в Конвенции, ни в протоколе к ней не предусмотрена дополнительная форма международной защиты для лиц.
Perdón, les pido silencio para poder escuchar al orador.
Конвенции, ни в протоколе к ней. Ни в Конвенции, ни в протоколе к ней не предусмотрена дополнительная форма международной защиты для лиц, ищущих убежище, кроме как признание лица беженцем. Поэтому в нашем национальном законодательстве нет других видов защиты в отношении лиц, ищущих убежище. Принимая во внимание создание в Азербайджанской республике эффективной системы убежища и права всех иностранцев и лиц без гражданства, ходатайствует о предоставлении статуса беженца обеспечивается без какой-либо дискриминации. Поэтому с 1 июля 2020 года процедура определения статуса беженца Управлением Верховного комиссара ООН по делам беженцев в Азербайджане полностью переустановлена. С этой даты ходатайство лиц, ищущих убежище, рассматривается только Государственной миграционной службой и национальными судами Азербайджанской республики. Те лица, которые являются мандатными беженцами или получили дополнительные формы международной защиты со стороны УВКБ ООН по делам беженцев в Азербайджане до 1 июля 2020 года ни при каких обстоятельствах не были направлены или принудительно возвращены в страну, где их жизнь и свобода окажется под угрозой. Требования статьи 15 Закона Азербайджанской Республики о статусе беженцев и вынужденных переселенцев соответствуют требованиям статей 32 и 33 Конвенции 1951 года. То есть статья называется «Высылка» и запрещение высылки беженцев или их принудительного возвращения в страны, из которых они прибыли. Лица, которым было отказано в предоставлении статуса беженца с правом обжалования решения и с учетом вытекающих из него вопросов, в конечном итоге, в зависимости от решения суда, добровольно покидают территорию Азербайджанской Республики в различных направлениях, если они не имеют основания проживать в стране на законных основаниях. В период с 1 января 2020 по 1 февраля 2024 года не принималось решение о возвращении, депортации или экстрадиции лиц, обратившихся за получением статуса беженца, а также лиц, которым статус беженца был предоставлен. Сейчас коротко хотел бы дать информацию, которая была вчера запрошена, о Мехмете Гелена, гражданина Турецкой Республики, 1985 года рождения. Он вместе с членами своей семьи 25 июля 2017 года обратился в Государственную миграционную службу Азербайджанской Республики за получением статуса беженца. Его ходатайство было зарегистрировано Государственной миграционной службой. В ходе собеседования он заявил, что не является членом какой-либо группировки в Турции и что он не располагает никакой информацией об интересе к нему со стороны властей. На основании фактов, изложенных заявителем в ходе рассмотрения заявления, вероятность того, что он подвергнется преследованиям при возвращении в Турцию, не рассматривалась как вполне обоснованное опасение преследования. Возможность подвергания каким-либо преследованиям оценивалась, ссылаясь на международные базы, собирающие информацию о стране происхождения. По результатам расследования его дела было принято решение от 25 октября 2017 года об отказе в предоставлении ему статуса беженца. Мехмед Гелен и его жена Мерьем Гелен обратились в Бакинский административно-экономический суд номер 1 в связи с оспариванием решения и предъявили требование возложить обязанность принятия решения о предоставлении статуса беженца в Государственную миграционную службу. Решением суда от 3 апреля 2018 года иск не был удовлетворен. Они подали в Бакинский апелляционный суд апелляционную жалобу на вышеупомянутое решение суда. Апелляционная жалоба, поданная истцами по решению суда от 22 июня 2018 года, была отклонена. Мехмед Гелен и его жена подали кассационную жалобу в Верховный суд Азербайджанской Республики на вышеупомянутое решение Бакинского апелляционного суда. Кассационная жалоба не была удовлетворена решением Верховного суда Азербайджанской Республики от 15 октября 2018 года. И решение осталось в силе без изменений. Спасибо за внимание.
With the permission of the chair, I will give the floor to the Zaur Ibrahimov, Deputy Chair of Social Service Agency under the Ministry of Labor and Social Protection of Population, to address the issue on assistance to the victims of human trafficking, adaptation and rehabilitation measures of the prisoners. You have a floor.
Thank you, Deputy Minister. Your Excellency, Committee Chairman, distinguished committee members, I would like to inform you about social works have been carried out with this sensible people, the group of people that our colleagues and the rapporteurs talked about. One of them is like this social service carried out about our institution, which is the Center of Assistance of Victims of Human Trafficking, subordinate in the Social Service Agency under the Ministry of Labor and Social Protection of Population, carries out following activities. So the first activity is that it implements rehabilitation measures to help victims of human trafficking reintegrate into society and return to a normal life. Next, center carries out social work with victims of human trafficking and potential victims of human trafficking, provides them with a social service. It provides legal, psychological assistance to the victims of human trafficking in order to restore their rights and to eliminate the physical trauma inflicted on them and their family members. Medical rehabilitation of victims of human trafficking also is a very important issue. So center implements therapeutic measures aimed to restoring impaired or lost functions, eliminates the consequences of their illnesses, injuries, complete or partial restoration of the physical and anatomical disorders. Center also assists in provision of professional training, retraining, and employment of victims of human trafficking and continuing their education. Lastly, I would like to also mention that the center is acting as a temporary shelter for victims of human trafficking and also suspected victims of human trafficking. Namely, for the year of 2020, the center has provided assistance to 291 victims. The victims assisted by the center are potential victims referred by the main directorate for combating human trafficking of the Ministry of Internal Affairs, as well as on the basis of personal appeals and referred by various non-governmental organizations. So the second institution that I want to give you information about, I will try to do it quickly. So it is the Department for the Social Rehabilitation of Victims of Domestic Violence. That was also pointed out by the rapporteurs about information about this sensitive group. So this department, which started operating on the 1st of August of 2021, it was established with the aim to provide the victims of domestic violence with assistance services that meet modern standards, prevent domestic violence, and take preventive measures in the area of achieve a long-term solution to the problem of domestic violence and its consequences. Since 1st of August 2021, 164 victims of violence have received social services. In total, social services have been provided to 1,052 people from vulnerable groups. I want to proceed my speech with the call center, which is 116123, which is called in Azeri Gayrı. It is a call center of the Social Service Agency. It started operating from the 1st of February 2022. The call center's purpose is to provide information, answer questions related to the activities of Social Services Agency directly after processing the appeal and offer advisory service to individuals and families in difficult life situations. In addition, it provides socio-psychological consultation, receive applications such as requests, complaints, proposals, and forward them to the relevant structural units. It should be also mentioned that the center activities included support line for the victims of the domestic violence. Between 2022 and June 2023, the center received 3,075 calls. As of June 2023, the center has been integrated into 142 call center, which is the call center of the Ministry of Labor and Social Protection of Population of Azerbaijan. Following the integration process, the 116 and 123 call center provides only uninterrupted 7/24 service only to victims of domestic violence. Incoming calls are promptly forwarded to the Social Services Agency, regional offices, and evaluated, and persons identified as victims of domestic violence are immediately placed into appropriate institutions. I just go quickly to the third subject that Madame Kahramanov also mentioned in her speech about the trainings about the domestic violence. Also, our ministry, our social service agents, which is under the our ministry, so it started since 2013. The Ministry of Labor and Social Protection of Population has been providing protection for persons in difficult living conditions by awarding government orders in the field of social services to non-governmental and non-profit organizations, including social orders to prevent domestic violence. All this implemented in accordance with the law of the Azerbaijan Republic on social services. There are two projects that I want to inform you related to domestic violence implemented in 2021. First project is increasing the knowledge and skills of civil society organizations in the fight against domestic violence has been implemented. The project aimed to increase awareness and knowledge of means of protection against domestic violence among the population, as well as to promote education in the field of combating domestic violence. And the next one is promoting trust in means of protection against domestic violence, promotion of adoption and attention in society to persons from vulnerable groups, aimed to promote awareness and educational measures in the field of preventing and combating domestic violence. The last one, if I have a time, I just want to quickly point out also Mr. Adilov's, in his speech, he talked about the work done with the persons who have been released from the serving sentences in the penalty institutions. So in 2023, on the social work carried out by the Social Services Agency under the Ministry of Labor and Social Protection of Republic of Azerbaijan, in order to assess the need of the social psychological service of persons who have been released from the serving sentences in penitentiary institutions, have been sentenced to parole, have been conditionally released from the punishment before the time limit, or have been suspended by the court. So the first one is conducting social work with the persons on probation in order to prevent recidivism of convicts who have been released from the serving sentences and released on the parole to the social, environmental, social rehabilitation. Oriented activities are carried out with the guide of Article 7 of the law of the Azerbaijan Republic on social adaptation of persons released from the serving sentences in penitentiary institutions. Article 7 and 23 of the law on social services, and Article 23 and subsection of the 3.1.10 of the Charter of the Social Services Agency. I'd like to draw your attention that social adaptation and rehabilitation of prisoners is being implemented together with the probation department of the Ministry of Justice, and during the year, an initial assessment was conducted with 64 people. 44 of them were evaluated in detail. An individual development plan was drawn up to 41 people, and the service was finalized with the other 23 people. In addition to this, let me elaborate further about conducting social work with the prisoners released from the serving sentences in penitentiary institutions. An initial assessment was conducted in the form of the questionnaire survey with 25 convicts in the penitentiary institution 3 months before their release after the completion of their sentences. Activities aimed at support their socio-psychological adaptation to society are performed. In conclusion, I want to add about social adaptation of the person released on amnesty. An amnesty was conducted with 3 people, women, who were released from the penitentiary by the president of our country, Mr. Ilham Aliyev, and the individual development plan was drawn about them, and the work is continuing at the moment. Thank you very much for your attention.
I thank you so much, Mr. Ibrahimov, for your information. I think that our Deputy Minister of Health wanted to add some points.
Да, благодарю. Благодарю. Я хотел бы к дополнению к механической фиксации дополнить, что в Азербайджане во всех психиатрических центрах работают по британским клиническим протоколам, переведенным на азербайджанский язык. Однако акцентирование на этом вопросе заставляет, я думаю, сделать нам мониторинг. Я думаю, мы будем делать мониторинг центров рандомный и проанализируем эту ситуацию. Спасибо вам.
Mr. Chair, yesterday we interrupted our discussions on the statement by the Minister of, from the representative from the Minister of Defense. If we have a time, with your permission, we can give him.
We have 5 minutes. For
5 minutes. Then, with your permission, Mr. Chair, I wanted to give the floor.
Спасибо за 5 минут. Я постараюсь. Я хочу дать ответ господину Бухвальду по поводу возмещения ущерба. Вчера был ответ на этот вопрос. У нас есть закон о возмещении ущерба. Соответственно, с этим законом суд должен вынести решение о возмещении ущерба, в том числе морального. Хочу, возможно, у вас нет полностью данных, значит, 18 человек по татарскому делу вынесен оправдательный приговор Верховным судом. В данный момент 3 из них получили решением суда, есть решение суда о возмещении ущерба. По времени сейчас они подают иск, должен рассматриваться, и будет решаться вопрос суммы, потому что они моральный ущерб, разные суммы озвучивают, поэтому будет решаться. То есть эта работа идет. И то, что вы вчера сказали, что 405 человек потерпевших по татарскому делу. Дело в том, что следствие признало их потерпевшим, но признало потому, что их незаконно лишили свободы. Но не ко всем из них были применены так называемые пытки. И к тому же в начале этого года судом были осуждены 7 человек, кроме 17 человек, в том числе высокопоставленный генерал азербайджанской армии, который по другому направлению, в другой войсковой части, тоже аналогичную, похожую деятельность совершал. То есть Азербайджан демократическая страна, она борется с пытками, и каждый, кто участвовал в этом, получит свое наказание, в том числе высокопоставленные лица, как видите, генерал осужден за это. Теперь, если вы разрешите, я хочу показать, в чем вчера остановился, на чем. После войны 2020 года мы провели мониторинг и посмотрели, что можно сделать еще по гуманитарному праву. И когда готовилась антитеррористическая операция, до этого мы приготовили буклеты, которые были, так сказать, разбросаны по Карабаху, где местному населению мы объясняли, в чем обращение. Мы обращались к вооруженным людям, которые там, не гражданам Азербайджана, вот буклеты, которые, чтобы они складывали оружие и так далее, что они не были, так сказать, к ним были применены какие-то меры. Вот эти буклеты. Также министр обороны издал приказ номер 122 29 апреля 2022 года о проведении необходимых мероприятий по соблюдению норм международного гуманитарного права должностным лицам азербайджанской армии. Подпись, которая была доведена под подпись всему личному составу азербайджанской армии. И после там есть пункты, допустим, высказывание ненавистных выражений в отношении лиц армянской национальности, пропаганда дискриминации, в местах дислокации частей подразделений азербайджанской армии, вход в церкви, другие места поклонения, кладбище, совершение вандалистских актов и оскорбительных действий в отношении всех видов памятников, артефактов, а также объектов, имеющих культурную ценность, являющихся историческим культурным наследием, действия, направленные на повреждение, уничтожение, деформацию и потерю ценности экземпляров культурного наследия зодчества. Согласно приказу, перед должностным лицам азербайджанской армии были поставлены задачи о привлечении в установленном законом, порядке к ответственности лиц, совершивших вышеуказанные деяния, а также в целях организации более широкого преподавания международного права. Хочу заметить, что после контртеррористической операции в 2023 году 4 лиц азербайджанской армии, совершившие нарушение прав Уголовного кодекса статьи 116, это нарушение норм международного права во время вооруженного конфликта. В отношении них было возбуждено уголовное дело по этой статье и направлено в следственные органы. То есть азербайджанская армия чтит нормы международного права. Мы постоянно работаем над этим. И спасибо за то, что вы дали мне возможность закончить.
Muchas gracias, señor viceministro. Quiero en nombre del comité agradecerle a usted y a todos los miembros de la delegación sus respuestas. y sus comentarios a los distintos y variados temas que fueron planteados durante estos 2 días. Como le llegué a mencionar, la delegación tiene un plazo de 48 horas para poder proporcionar cualquier información adicional que ustedes estimen que sea conveniente para las deliberaciones del comité. Se ha hablado de estadísticas, se ha hablado de cuestiones muy puntuales y también que puedan abordar tal vez cuestiones que no hubo el tiempo necesario para poderlas responder. El 9 de mayo a las 6 de la tarde, la misión aquí en Ginebra va a recibir el documento que nosotros llamamos observaciones finales, es decir, a partir del diálogo que hemos tenido con ustedes, el comité va a elaborar un documento final de observaciones finales que se les remitirá no para que entren en el detalle de la sustancia, pero sí tal vez corregir nombres de instituciones, fechas, lo que sea necesario precisar. Y el 10 de mayo daremos a conocer públicamente las observaciones finales de los 6 estados que estamos examinando en este periodo de sesiones. Quisiera tal vez precisar que tendremos que en toda observación, documento de observaciones finales, destacamos 3 o 4 asuntos que consideramos como prioritarios y que pueden ser cumplidos o alcanzados en el plazo de un año, ¿no? Sí, lo que nos interesa mucho al comité es mantener un contacto permanente con los estados a través de este diálogo y este proceso. También ustedes recibirán ya posteriormente una misiva por parte del relator de seguimiento de las recomendaciones bajo el artículo 19 para ver de qué manera ustedes vienen cumpliendo o aplicando las recomendaciones que el comité les está formulando. Recomendaciones que a juicios del comité podrían ayudarles a ustedes como Estado parte de la Convención a cumplir con todas las disposiciones. No son una imposición, es una recomendación, una llamada de atención sobre los cuales el comité desea enfatizar para su consideración. Quisiera destacar el espíritu constructivo y positivo que ha tenido este intercambio. Creo que hemos hablado de 2 temas fundamentales. Uno, la situación en Azerbaiyán, pero también hemos hablado de una guerra y obviamente que sí nos preocupa al comité en un contexto internacional en que proliferan conflictos, guerras, en que obviamente se cometen por las partes graves violaciones de derechos humanos, incluyendo la tortura. Hemos recibido información indirecta de que están en un proceso de buscar un acuerdo con Armenia. Esperamos que en términos de paz esto sea un objetivo alcanzable que obviamente sería muy apreciado no solo por nosotros, sino por la comunidad internacional. Y no me queda más, señor viceministro, que cederle la palabra para su intervención final. Tiene usted la palabra.
Mr. Chairman, before I will make my concluding remarks, Maybe one question I wanted to raise. You mentioned that on 9 May you are going to present the concluding observations. On 9 May we have a holiday, and maybe it will be possible to present it or 2 days before or 2 days later of the day of 9 May. Thank you, thank you, Mr. Chair. In conclusion, once again, I would like to underline that the government adherence to the protection and promotion of human rights and fundamental freedoms at the national level, and we consider all relevant UN treaty bodies mechanisms, including the CUT review, as a good opportunity for all of us to declare what actions have been taken by the government to further improve the human rights situation in the country and what challenges it faces in fulfilling its obligations. We also proceed from understanding that the review mechanism constitutes an essential tool to share best human rights practices in order to enhance capacity to deal effectively with possible human rights challenges. Bearing this in mind, my country is among those ones who constantly and timely presents its periodic reports to all human rights treaty bodies and the Human Rights Council, including the interim reports on a voluntary basis. Since the last periodic review, my government continued to undertake all necessary measures to enhance the human rights records in the country, including on prevention of torture, and with that purpose adopted several laws, enacted the number of programs, national plans, and strategies to ensure in practice compliance with the state's obligations under the convention. Unfortunately, the time allotted for the delegation does not allow to provide the overall information on the reforms in the country and measures taken to implement the recommendations made following the last review. Despite the general spirit of cooperation that always existed in this audience, any recommendations that does not based on established facts and reports received from the credible sources, questions that do not fall into the committee's mandate do not contribute to the review process. Irrespective of that, my delegation considered today's dialogue as very engaging and productive and expressed its readiness to further cooperation. I would like to thank the esteemed rapporteurs, members of the committee, special thanks for the chair, for productive dialogue and our delegation, without the delegation, as well as express appreciation to the interpreters for the great job done. I thank you.
Muchas gracias, señor viceministro. Repito que el comité actúa con la mayor independencia, profesionalismo cuando elabora sus recomendaciones y cuando analiza la información que tiene disponible sobre un estado parte, y estoy seguro de que ese es el espíritu que va a predominar cuando elaboremos las observaciones finales. Les agradecemos un feliz retorno, agradecemos su desplazamiento a Ginebra, y antes de levantar la sesión les recuerdo a los miembros del comité que mañana nos reuniremos a las 11:30. Muchas gracias, se levanta la sesión.